on up to the podium with your client.
Yes, ma'am. Thank you.
Good afternoon, Mr. Ed.
Good afternoon, Your Honor. How are you?
Doing great. How are you doing?
Good, thank you.
All right, this is cause number CR 18295, motion to revoke on Jared Grant Anderson. Go ahead, Mr. Head.
Your Honor, I was visiting with my client. He has actually not been served with a copy of the motion yet. It's his understanding that it's a deferred adjudication. So I would assume that it is a motion to proceed. I've not received a copy yet either, although I do think I received something through the portal. I was not able to open it. I've had some technology issues. So we're going to ask that the court reset the motion to revoke or motion to proceed to give us adequate time to be served and review it. I would ask that the court, if it is a motion to proceed, that the court allows to put on testimony related to our motion requesting bail if it's a motion to proceed.
Sure, I'll tell you what I'll do. I will grant that reset, but I'm going to go ahead and display it just so you can go ahead and read up on it, and then we'll get you a copy.
Yes, sir.
As well. So.
That certainly would appear to be a motion to revoke, Your Honor, as opposed to a motion to proceed.
Yes, sir. I think that's correct. Let's see. Ms. Burns, are you in the courtroom out there?
Yes, sir. I'm printing him out a copy.
Okay, great. That's what I was going to ask you to do. Okay. All right, Ms. Burns, so I'll get you a copy of that for Mr. Anderson and then for you as well, Mr. Head. So court will reset Mr. Anderson's motion to revoke. Today is June 1st. My next evidentiary hearing, Mr. Head, would be either June 29th or July 25th. If one of those is better than the other.
Your Honor, if we could have the June 29th, I think that would give us adequate time to prepare. I do anticipate that we may have some witnesses. In fact, we have some that are present here today. Will they be allowed to come back in here and testify in this environment, or if we're going to present some witnesses, do we need to have this in a different area where just procedurally, I just wanted to check, see how the court wanted to communicate that.
Sure, and you're talking about in the future on the 29th?
Yes, sir, Your Honor.
So what I'll do is I'll have on the evidentiary days when we have contested hearings, we'll do everything in the courtroom.
In the actual courtroom at the
Yeah, yes, we'll bring Mr. Anderson over and then you'll have access to this there.
Yes, sir.
All right. Oh, it's okay, no problem.
Was that 1:30, Your Honor, on the 29th or 9 a.m.?
Yes, sir. It'll be 1:30. So we'll do our inmates at 1:30 and our people on bail at 9.
Yes.
June 29th at 1:30 in the courthouse.
Yes, sir. And will based on it being a motion to revoke, as opposed to a motion to adjudicate, is the court willing to entertain our motion to request bail, or is that denied?
I don't know if I've reviewed your motion. Has the state been provided with a copy of that motion?
Your Honor, we filed it back on the 17th of May. And I think the court actually already ruled on it.
Okay. Let me look here. And I'm sorry, it's been a moment. Let's see. Okay, I find it now. Okay. It looks like I did entertain that motion. It looks like I denied it on May 18th. And I think I did so largely because it is a motion to revoke, and one of the allegations was failure to report.
Yes, sir, Your Honor.
So yeah, bail is denied at this time.
Yes, sir. And as far as the reset form, I guess I apologize. I'm just not real familiar with the court's process.
Yeah, just put that reset date on there, 6/29, today's date, contested empty, or check that off. Have Mr. Anderson sign that. He'll get the yellow copy, and then you can just leave the white copy with us.
Yes, Your Honor. Thank you, Your Honor.
You're welcome. Thank you, Mr. Ed. Who do we have ready now? Deputy, please.
The attorneys are still working, Your Honor, but we do have Glenn Smith in the room.
Okay, let me look at that case up real quick, and I do have Mr. Donner available.
Step up with me, please.
All right, good afternoon, Mr. Donner. Mr. Donner, can you see and hear me okay?
Can you hear me, Your Honor?
Yes, I can hear you. Can you hear me?
I can't hear you.
Mr. Woodbine, can you hear me okay?
Let me see.
Yes, Your Honor, I can.
It may just be a volume button. Let me see if I can see
Oh.
this.
Um, um, this,
How about now?
wait. Um,
Can you hear me now? No. That spokesperson for Verizon, he made a lot of money saying, "Can you hear me now?" I think I'm gonna make that same kind of money from saying
You had a penny at it every time, Judge.
every time.
I think I got it fixed.
Okay, can you hear me now?
Yes.
Excellent. Okay. All right, this is cause number CR 21-92, State versus Glenn Allen Smith. And Mr. Dahlman, it's my understanding that you're standing in for Mr. Flory. Is that correct?
Well, Your Honor, we'll be filing a motion, or not a motion, a letter of representation for me. Mr. Fleury is with the firm. He originally handled the DWI that this is a revocation on, so his name just stayed on the case. The firm represents Mr. Smith, so I'll be handling it, and we'll get the necessary letter of representation to the court.
Okay, great. Thank you. All right, this being the first setting for motion to revoke, I'm under the impression that you're not ready to make an announcement today on the case. Is that correct?
No, Your Honor, we're not. I've spoken with the state and I've spoken with probation and have their recommendations. I went and visited Mr. Smith in the jail before I left Canton to discuss our options with him. There's also a revocation, I believe, in Kaufman County that we want to just make sure that everything is together in a row so that everybody's doing the same thing on this case.
Okay. How about I set this for our evidentiary hearing on June 29th? Give me 4 weeks.
That should be plenty of time. Do you have a sooner docket that we could get to? Because I don't think it's going to take very much time, because our attorney was in Kaufman County today for the case. So I think if there's anything sooner, we could do that.
Well, there is sooner, not as far as a contested hearing. If it's a
Okay.
plea agreement, yes, I can do it sooner. If it's a contested hearing and asks the court to make a decision, then the 29th is the date. But I can set it as early as June 13th, 15th, or 27th if y'all have an agreement. And it-
Let's set it for,
So what I would suggest is this, is let's set it for the 29th, and if you reach an agreement with the state, you contact Ms. Taberham, and she'll just schedule you. That way, if
absolutely.
there's no agreement, then we can have a hearing on the 29th.
That sounds perfect, Judge.
Okay, all right, we'll see Mr. Smith then on June 29th, unless something gets worked out, and we'll hear him soon.
Excellent. Thank you very much, Your Honor. Am I excused?
You are excused. Thank you, sir.
Thank you, Judge.
Anyone else ready?
Mr. Manning says he can go. Does have a couple ready?
Okay. Who are you ready on first? Mr. Lejean? All right, this is cause number CR 21-402, State versus John William Lejean Jr. And go ahead, Mr. Manning.
Yes, Judge. As we discussed previously, he is going to be taking the state's offer of 4 years TDCJ, a fine of $1,500, court cost of $209, reimbursement of $35 on the third-degree felony evading arrest detention of the vehicle.
And jail time credit,
2 days.
2 days,
That's correct, Judge.
any 1245s?
No, Judge. This was a singular offense.
All right, Mr. Lejean, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Mr. Lejean, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any mental conditions?
Yes, sir.
Can you tell me about that?
I've had a couple stints in Green Oaks and Wichita Falls.
Do you know what your diagnosis was? Like what specific condition?
Bipolar, depressive, schizophrenia, all sorts of stuff.
Are you on any type of medication or under a doctor's care for that?
No.
All right, do you feel like in any way those things are making it to where you don't understand what's going on in court today?
I don't know what's going on in court.
You understand everything?
Yes.
All right, and in this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's work as your attorney?
Yeah.
Do you feel like you've had enough time to talk to him about your case, and that you've had all of your legal questions answered?
Yes, sir.
Is there anything, Mr. Lejean, that you've read over and signed today in that paperwork that you do not understand?
No, sir.
Mr. Manning, do you believe Mr. Lejean to be competent?
I do, Judge.
Do you believe he's entering into this plea intentionally, knowingly, and voluntarily?
I do.
All right, Mr. Lejean, you are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle. A third-degree felony does carry a range of punishment, the minimum 2 years in prison to a maximum 10 years in prison, and a fine if imposed not to exceed $10,000. I see the plea agreement in your case fits squarely within that legal range of punishment. Understanding the plea agreement as read to the court by Mr. Manning, your attorney, understanding the range of punishment. Mr. Lejean, at this time, you still wish to go forward with your plea?
Sir.
So, Mr. Lejean, with that said, how do you plead to evading arrest or detention with the vehicle?
Yes.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, yes.
You guess, or I mean, are you pleading guilty because you are guilty? You're not just pleading guilty so you can get a 4-year offer and a reduced sentence or anything of that nature. Is that correct?
I just don't want to get, I just want to get this over with.
Mr. Manning, I'm gonna need you to talk with your client and let him know what the requirements of the court are before I can accept a plea agreement, and a plea of guilty. He says, I guess I'm guilty and I just want to get this over with. That gives me concerns and he's not pleading freely and voluntarily.
Judge, we've had an opportunity to discuss the discovery multiple times. I think what we are facing is, this is not the outcome that Mr. Lejean had hoped for. He has really turned his life around since the time of offense, and was really hoping for a chance to continue the steps he'd made by his education, his job, his family. And so unfortunately that opportunity wasn't availed us by the DA's office and their offer. And so I think that's the reason for his hesitancy, but we have discussed the legal requirements for this offense, potential defenses for this offense, as well as the discovery in this case.
Mr. Lejean, one of the things that I, as a judge, have to do in a court is make sure that people who are pleading guilty, they're pleading guilty because they're accepting legal responsibility for a crime and that they're not just saying one thing to get another. I understand that this may not be the outcome that you wanted or wished for, but at this time I need to know, are you pleading guilty to evading arrest or detention of the vehicle because in fact that's what you did and you're taking legal responsibility for that? And that's the only reason you're taking this deal?
Well, I really stopped the motorcycle. I don't really feel like I told him I wasn't running. I was just mad. I freaked out. I was under emotional stress. I mean, I stopped the motorcycle. He didn't wreck me out. I put the bike and I got down on the ground and said, I'm not running from it. I was just mad and pissed off. That's it.
But you did flee from the officer who was attempting to stop or detain you.
No, I was driving crazy trying to hurt myself, really. If you look at the video, you see me in the ditch, like riding the top of this motorcycle. I was trying to hurt myself, really, intentionally, if all motives were. And then when I realized that, hey, I don't want to hurt myself, I'm not running, that's what I did. I wasn't trying to evade arrest from the officer or nothing.
So what I'm hearing you say is that you don't believe that you're guilty of this offense.
I just don't want to get in any more trouble. I just, you know what I'm saying? I'm here to face it. If I've got a record that stems a mile long, and I'm just here to do it. I don't need more time, or you know what I'm saying, or I don't want to make the DA mad, or I'm just sitting here trying to get and take care of it. I need this off of me because I mean, I'm doing good. I've got a job, I've got a family, and I'm ready to get it done. You know what I mean?
I understand. And the only thing that stands between you and that is whether you can look me in the eye and tell me that you're pleading guilty or not. Saying I guess so is not going to. So I need to know, are you guilty of committing this crime or are you not?
Your Honor, if I may have a moment to discuss with my client.
Sure. Yeah.
Well, I mean, I just I'm guilty, sir.
All right. So you're pleading guilty to this offense, correct?
Yeah.
All right. And Mr. Lejean, has anyone threatened, forced, or pressured you to plead guilty today?
No.
All right. Court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the state's evidence supporting the plea?
No objection to state's one.
States one is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor, we had rest and close.
Anything further from the defense?
Rest and close, Judge.
All right, the court will accept the defendant's plea of guilt and the court takes judicial notice of Mr. Lejean's judicial confession. Mr. Woodwhite, can you give me the facts to support the plea? And I've already heard some of them, I believe, from the defendant's perspective, but if you can give me state's evidence.
Yes, Your Honor. On the date in question, which is 6/16/2021, Grand Saline Police Department attempts to pull the defendant over for obstructed license plate on his motorcycle. The defendant fails to yield and accelerates to over 90 miles an hour for just over 3 miles until he drops his backpack, attempts to pull a U-turn and lays the bike on its side and is taken into custody. He admits to seeing the officer, but said he wanted to get to work and wanted to finish his Monster Energy drink before throwing it away.
All right, thank you, Mr. Woodway. Mr. Manning, any objection to that summary?
Judge, with the particular differences from my client's perspective, that is generally what happened and is what's on video.
All right, thank you. All right, then based on the evidence, the court will find that there is sufficient evidence to convict Mr. Lejean of this offense. Court follows the plea agreement, sets a sentence at 4 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,500 fine, $290 court costs, $35 in reimbursement fees. The court awards Mr. Lejean 2 days credit towards this sentence for the time that he has spent in jail on this cause. Mr. Lejean, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy and she's going to take your fingerprint.
Sir.
Anyone else you're ready on, Mr. Manning?
Yes, Judge. Ready on Mr. Benbow.
All right, this is cause number CR 23-89. And I believe that we were set for arraignment. I have a notation. This is also CR 23-88. Is Mr. Benbow entering into a plea today, or are we just arraigning?
Judge, he is entering into a plea today, and we're gonna resolve both CR 23-88 and 89.
Okay, go ahead and give me the terms.
Judge, upon plea of guilty of evading arrest, detention with the vehicle, CR 23-88, state agrees to recommend that punishment be assessed at 3 years TDCJ, institutional abuse, a fine of $2,500, restitution of $180 from DA case number 2023-294, as well as 1245 CR 23-89, which is the fraudulent use, possession of identifying information. As I said before, they're going to be rejecting the DA 2023-0294. That's a possession of controlled substance less than a gram. Mr. Benbow, in addition to his fine, has $290 court costs, $180 restitution, $20 reimbursement, and he has 129 days jail credit.
You said $20 reimbursement, 20?
Yes, Judge.
All right, Mr. Benbow, sir, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Good luck again. All right, Mr. Benbow. Are you a United States citizen who reads, writes, and speaks English?
I am.
Have you ever been diagnosed with a mental condition?
No, sir.
You're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done as your attorney?
Yes, sir.
Do you feel like you've had enough time to talk with him about your cases and that you've had all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you read over and signed today that you do not understand?
Yes, sir.
Mr. Manning, do you believe Mr. Benbow to be competent, and have you explained to him his rights as they pertain to both these cases?
I do believe he's competent, and I have explained his rights. Yes, Judge.
And you believe that he's entering into this plea intentionally, knowingly, and voluntarily?
Yes.
Mr. Benbow, you've heard the plea agreement read to the court by Mr. Manning. Is that your understanding of the plea agreement and what you're asking the court to approve today?
Yes, sir.
All right, Mr. Benbow, I see that in CR 23-88, you are charged with a third-degree felony offense of evading arrest or detention with a vehicle that does carry a range of punishment to the minimum 2 years in prison to a maximum 10 years in prison. And I see that the 3-year recommendation would fall squarely within that. Understanding the plea agreement, understanding the range of punishment. At this time, I'd ask you, Mr. Benbow, how do you plead to evading arrest or detention with a vehicle?
Guilty, sir.
And are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court accepts Mr. Benbow's plea of guilt. Mr. Manning, any objection to the evidence offered by the state to support the plea?
No objection to stage one.
States one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
Anything further from the defense?
Rest and close, Judge.
All right, Mr. Woodward, can you give me the state's evidence to support the plea?
Yes, Judge, on February 4th of this year, the Canton Police Department gets a notification that a stolen truck is eastbound on I-20 at 4:30 in the morning. Gets behind the defendant, confirms that the truck has been reported stolen, and attempts to pull him over. The defendant accelerates down the highway. He evades, swerving in between lanes. Eventually, he attempts to exit the highway by slamming on the brakes, and which causes a sheriff's deputy to impact the back of his vehicle, which disables it. He is then arrested and taken into custody.
Thank you, Mr. Woodward. Mr. Manning, any objections?
No objections.
All right, then based on the evidence presented, the court finds that there is sufficient evidence to convict this defendant of this offense. Court, in accordance with plea agreement, convicts Zebulon Thaddeus Benbow of evading arrest or detention with a vehicle. Assesses punishment at 3 years confinement. Texas Department of Criminal Justice orders a $2,500 fine, $180 restitution, $290 in court cost, $20 in reimbursement fees, and awards Mr. Benbow 129 days credit towards his sentence, the time that he has spent in jail on this cause. In addition, the court dismisses CR 23-89 under section 1245 of the Texas Penal Code. Mr. Benbow, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy to be fingerprinted. Ready on anyone else?
Judge, next we're ready on Mr. Joshua Prater.
All right, Mr. Prater, if you'll make your way forward. CR 19-244. I believe this is a motion to revoke. Is that correct?
That's correct, Judge.
And is Mr. Prater going to be pleading true today?
He is, Judge. My understanding of the agreement was that he was going to be pleading true to all but count one, which was a rejected new offense. However, on the judgment, it shows that that is still part of the plea agreement.
Any comment by the state?
If you give me a moment, Judge, I'm trying to pull it up. This is Ms. Heisel's case. Judge, we would abandon count one if we'll get a corrected judgment that reflects that we are not proceeding on count one.
Okay, thank you, Mr. Wood. Mr. Manning, you said that Mr. Prater would be pleading true to counts 2 through, what do we have here? 11?
That's correct, Judge.
Okay. All right, Mr. Prater, if you'll raise your right hand, sir, I'm going to place you on oath. Sir, do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help me God?
Yes, sir.
All right, you can argue. Mr. Prater, it appears that you were before the court on October 24th, 2019, pled guilty to possession of controlled substance, a state jail felony. Court heard the evidence, followed a plea agreement on that day, assessed your punishment at 2 years confinement in the state jail division of TDC. But the court suspended that sentence and placed you on probation for a period of 3 years. It was during that period of probation that the state filed its motion to revoke on November 18th, 2021. And within that motion, they've alleged 11 separate counts of ways that you have violated your community supervision. That's my understanding that you're going to be pleading true to counts 2 through 11. This time, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and his work as your attorney in this case?
Yes, sir.
Do you understand everything that you've read over and signed today?
Yes. Yes, sir.
Mr. Manning, does your client waive the formal reading of the state's motion to revoke?
He does.
All right, so, and Mr. Manning, do you believe Mr. Prater to be confident that he's entering the plea intentionally, knowingly, voluntarily?
He is confident and he is pleading intentionally, knowingly, and voluntarily.
Thank you, Mr. Manning. All right, Mr. Prater, then I'm going to ask you, how do you plead to counts 2 through 11. Are those counts true or not true?
True.
And are you putting true to these accounts 2 through 11 because in fact, what is being alleged by the state is in fact true?
Yes.
No one's threatened you, forced you, or made you plead true to counts 2 through 11 today. Is that correct?
Yes, sir. I mean, no, sir. No, sir.
That's all right. I understand. All right, then the court will accept Mr. Prater's pleas of true through counts 2 through 11. Mr. Manning, is there any objection to the admission of the defendant's waiver of rights plea of true?
No objection.
Court will admit that into evidence. Court takes judicial notice of Mr. Prater's judicial confession. Is there anything further from the state?
No, Your Honor, we would rest and close at this time.
Anything further from the defense?
Besides the count 1, there's nothing from the defense.
And Mr. Manning, I sent that to Miss Burns, so just replace that one page that reflects that.
And Mr. Manning, I think I failed to ask, what are the terms of his plea agreement today?
Judge, upon plea of true, the state's motion to revoke community supervision will be revoked. Punishment assessed under 1244A at 68 days confinement in Van Zandt County Jail, credit for time served, and a balance of financial obligations. As part of this agreement, Mr. Prater's family paid a significant portion of his back fines, court costs, as well as his probation fees. And that was done prior to today. I believe he still has remaining balance that he says he'll be able to get taken care of, which includes the new attorney's fees for today's proceedings.
Is that right, Mr. Prater?
Yes, sir.
All right, then pursuant to the plea agreement and the evidence, court hereby finds that Joshua Prater has violated the terms and conditions of his community supervision. Court hereby revokes his community supervision, assesses his punishment at 68 days confinement in the Van Zandt County Jail. Court will issue him credit for time served, for time spent in jail on this matter under section 1244A of the Texas Penal Code. The court will order him to pay the balance of his financial obligations. Mr. Prater, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Once you do get released from custody, just make sure that you report to the Van Zandt County Courthouse to finish paying off what you owe, okay?
Yes, I can do that today, sir.
All right, thank you, sir. Who's next, Mr. Manning?
Judge, Ms. Kristen Sipes.
All right, Ms. Sipes. This is cause number CR 22394, State versus Kristen Lee Sipes. Is Ms. Sipes taking a plea agreement today, Mr. Manning?
Yes, Judge.
All right, what are the terms?
Judge, the state has filed a motion to proceed on Ms. Sipes' probation that she was put on March 30th, 2023. Ms. Sipes will be pleading true to both of those counts. And upon a plea of true, the state's motion to adjudicate, the agreement is that defense will be adjudicated, community supervision be revoked, punishment assessed at 9 months state jail, and a balance of financial obligations. Additionally, she has 58 days credit and the remainder of her financial obligations.
And you said 58 days credit?
That's correct, Judge.
All right, just look for motion. Mr. Manning, does your client waive the formal reading of the state's motion to adjudicate?
Does, and we have a copy and have reviewed that again today.
Okay. All right, Ms. Sipes, you appeared before the court on March 30th, 2023, and you pled guilty to possession of a controlled substance, a state jail felony. Court heard the evidence, found that there was enough evidence to convict you. Court followed a plea agreement that you reached with the state on that day. The court deferred a finding of guilt, placed you on community supervision for 3 years, assessed a fine of $2,500. And subsequent to that, the state filed a motion to adjudicate and revoke on April 11th, 2023. And they alleged in that motion to revoke 2 separate counts of alleged violations. This time, Ms. Sipes, I would ask you, how do you plead to counts 1 and 2? Are those counts true or not true?
They're true.
And are you telling me that each one of those are true because what is alleged is in fact true? You're not just saying that to get a certain plea agreement, is that correct?
That's correct.
Okay. All right, the court will accept Ms. Sipes' plea true to counts 1 and 2. Mr. Manning, any objection to the evidence, to the admission of the defendant's waiver of rights and plea of true as evidence?
No objection to the state's offer of the defendant's waiver and admission to the violations.
That's admitted in evidence. The court takes notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close.
Anything further from the defense?
Let's suppose, Judge.
All right, then based on the evidence presented, the court finding that Ms. Sipes has judicially confessed, the court finds that Kristen Lee Sipes has violated the terms and conditions of her community supervision. The court will follow the plea agreement in this case. The court adjudicates her guilt, revokes her community supervision, assesses her punishment at 9 months confinement in the State Jail Division of TDC, orders her to pay the balance of her financial obligations, and awards her 58 days credit towards that sentence for the time that she's already spent in jail on this cause. Ms. Sipes, whenever you are released from state jail, it's important that you report to the courthouse so that you can set up arrangements, the payment plan to pay off your financial obligations. Failure to do so could result in the court issuing a warrant for your arrest and putting you back in jail. So it's important that you do that. You understand that?
Yes, sir.
Okay. All right, Ms. Sipes, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy to be.
Go ahead.
Judge, I'm still working on the paperwork on a couple other ones as well as I have some announcements. I believe Mr. White's ready on his.
Okay, thank you, Mr. Manning. Mr. White, are you ready, sir?
Yes, Your Honor.
All right, Mr. Atkins, if you'll step on up. All right, is Mr. Atkins entering a plea today?
That's correct, Your Honor.
All right, Mr. Atkins, if you'll raise your right hand, I'm going to place you under oath. Mr. Atkins, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand to speak up loudly and clearly for me. Mr. White, can you tell me what the terms of the plea agreement are?
Yes, Your Honor, we are being offered a deferred adjudication for 10 years. And we are going into safety with special needs. There's a $2,500 fine as well as $35 in restitution.
And this, can you tell me which case that's on? Because he's got 3 here.
It's on a CR 22368.
All right, CR 22368. So I'm going to repeat what I heard. 10 years deferred, safe P as a condition. What was the fine?
$2,500.
$2,500, $290 court costs. Any reimbursement fees?
There's reimbursement fee of $35.
$35. And is there a 1245 or dismissal of the other 2 cases?
I believe it's 1235, but Mr. Woodwick probably would be able to tell you a little bit better.
Yes, our offer is to 1245 the other 2. If Mr. White does not have that paperwork, we'll make sure that it is presented to the court shortly.
All right, so just so I'm clear, the offer is 1245, calls number CR 22-1 and CR 22-236.
Yes, Your Honor.
Okay. All right, Mr. Atkins, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition?
Yes, sir.
Can you tell me about that?
I have bipolar and PTSD diagnosed at the Andrews Center.
All right. Are you on medication or under doctor's care for either of those?
Yes, sir. I go see the doctors and I'm on medicine.
Okay, good. So do you feel like you have a rational understanding and clarity of mind and thought today to understand what's going on in court?
Yes, sir.
All right. And you're represented by your attorney, Mr. Jeff White. Are you pleased with the work that Mr. White has done as your attorney?
Yes, sir. Very pleased.
Do you understand everything that you've read and signed?
Yes, sir.
And do you have any questions about the paperwork that you signed today?
No, sir.
Mr. White, do you believe that Mr. Atkins is competent today?
He's competent to make the decisions he's making today, and I believe he fully understands the ramifications and everything I explained to him.
And do you believe that he's entering into this plea intentionally, knowingly, and voluntarily?
Yes, Your Honor.
Okay. All right, Mr. Atkins, you are charged by indictment with a third-degree felony offense of assault of a family or household member by impeding breath or circulation. That does have a range of punishment with a minimum of 2 years up to a maximum of 10 years and a fine which cannot exceed $10,000 if imposed. If the court accepts this plea agreement today, then what that means for you that during the next 10 years while you're on community supervision, if you violate any of the terms of your community supervision, the state of Texas, the prosecutors could file a motion to adjudicate your guilt. That means to convict you. And the court, the state could ask the court to do a number of things. The state could ask the court to convict you, to revoke your community supervision, and they could ask the court to impose sentence anywhere on that minimum 2 years up to the maximum 10 years. You understand that possibility and that risk.
Yes, sir.
In understanding that, you still wish to go forward.
Yes, sir.
All right, then I would ask you, Mr. Atkins, how do you plead to assault of a family or household member by impeding breath or circulation?
Guilty, sir.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
The court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No objection, Your Honor.
State's evidence and the stipulation is admitted and the court takes judicial notice of Mr. Atkins' judicial confession. Is there anything further from the state?
Judge, we're in compliance. I do believe there is a victim impact statement in this case. I believe it was sent to your office either yesterday afternoon or this morning. I will also relate to the court that the victim is supportive of our plea.
Great, thank you, Mr. Woodwalk. I do appreciate that, and I do have the victim impact statement here with a tracking form, and I'll review that at this time. All right, the court has reviewed that victim impact statement. I will return that to the state. All right, anything further from the defense, Mr. White?
No, Your Honor.
All right, Mr. Woodwhite, can you give me the facts to support the plea?
Yes, Your Honor. On September 22nd of 2022, the sheriff's office is called out for a disturbance. Upon arrival, the victim, who is the defendant's girlfriend, has a distinctive handprint on her throat. The victim states that she and the defendant were talking. The defendant went to reach into her purse. She pulled it away, and then he struck her in the face. She tries to go inside, in which he gets behind her, wraps an arm around her, and grabs her by the throat and squeezes, making it hard for her to breathe. She gets away from him and tells him that she is going to call the police, and he leaves.
Thank you, Mr. Woodwhite. Any objections, Mr. White?
No objection.
All right, then based on the evidence that's presented, the court finds that there is sufficient evidence to convict Mr. Atkins of this offense. The court will follow the plea agreement today. The court hereby defers a finding of guilt in CR 22-368. Court orders that as a special condition of community supervision that Mr. Atkins attend and complete the substance abuse felony punishment facility, also known as safety. Orders him to pay a $2,500 fine, $290 court cost, and $35 in reimbursements. Court also takes into consideration and dismisses under section 1245, cause numbers CR 22-1, assault of a peace officer, and CR 22-236, injury to an elderly or disabled individual. Mr. Atkins, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over with a deputy to be fingerprinted, and then Mr. Atkins, obviously you're aware that you will be taken into custody to await a bed at the safety facility. Ms. Burns, do we know what the average wait time is right now for Mr. Atkins on that same week?
It's 2 to 4 weeks, somewhere in that range.
Thank you.
Beautiful. He's not special needs or anything, is he?
He will be special needs.
He is. Okay, what's the wait time for non-special needs right now?
Let me look.
Go ahead, Mr. Atkins, you can step up. I just
Thank-
want to find out.
Thank you for that.
Mr. Bond.
You're welcome.
Thank you.
Is that all you have today, Mr. White?
That is it, Your Honor.
It was good to see you, sir.
Good to see you.
There's about a week or two wait for regular needs.
Okay, so week or two regular and then double that for special.
She said we replaced. Jeff misplaced these motions, so she said. Mr. Atkins. First. Two faces. One was that I have. Yeah.
That's one going up this season. That's me 20. It's 23, the 70 back and there, clean it up.
They moved it up.
Yeah, that's right. We originally planned to finish having a conversation, discussing the state, the question you sent on June 24. That's about right. Okay. Yeah. Okay. And this is for official.
No, just that one. Just cars and charges. Class A. Then I picked up a class B. Out of the 2 months, 4 months after. Then. Look at my career goal. I've never been on it with all those. That's one that I ate for them. I wasn't allowed to, so, you know, that's when I got it out and paper from back. We never even, that was a the charge of the family violence. No, yeah, that's the origin.
Okay. Continue looking for Ms. May. I was gonna get some resets, and I don't know. I think I have a question for you. Oh, did you? Yes, sir. Go there. I'll see it. Yeah, she loved you. Outside here. Trying to respect the medical issue that you were having, sir. Don't want to violate your HIPAA.
Mr. Manning, are you ready, sir?
Yes, Judge.
And who are you ready on?
We have Mr. Christopher Quintanilla.
All right, Mr. Quintanilla. Look this one up. Did we add him to the docket?
Yes, Judge. He was a late ad. I actually ran into Mr. Quintanilla yesterday in Kaufman County, and we were able to get him before he heads down to TDC.
Okay, let me look him up. With explain this case number and stuff. Have that.
The case, are you asking for the case number?
That's okay. I'm gonna pull it up anyway. All right, it's gonna be what, CR 2368.
That's correct, Judge.
All right, is Mr. Quintanilla going to be entering a plea to a state jail felony possession of marijuana?
That's correct, Judge.
All right, what are the terms of the plea today?
Upon a plea of guilty, state has agreed to recommend that punishment be assessed at 9 months state jail with a fine of $500. Mr. Quintanilla has 102 days credit. And there are court costs in the amount of $290 and reimbursement in the amount of $85.
All right, Mr. Quintanilla, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thanks. So you can lower your hand. Your name is Christopher Quintanilla, is that correct?
Cool.
And Mr. Quintanilla, are you a United States citizen who reads, writes, and speaks English?
Yes, sir, I am.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done as your attorney?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir, there's not.
Okay, Mr. Manning, do you believe Mr. Quintanilla to be competent to enter into this plea agreement today?
He is, Judge.
And you've explained to him his rights,
I have.
and you believe that he is making waivers of rights intentionally, knowingly, voluntarily as he enters into this plea.
I do.
All right, and Mr. Quintanilla, you've heard the plea agreement that Mr. Manning read into the record. Is that your understanding of the plea agreement?
Yes, sir.
All right, the range of punishment for this type of offense is a state jail felony, which has a range of punishment of not less than 6 months in prison or more than 2 years in prison, and a fine which cannot exceed $2,000. So understanding the plea agreement, understanding that range of punishment, Mr. Quintanilla, how do you plead to possession of marijuana greater than 4 ounces less than 5 pounds?
Guilty.
Are you pleading guilty to this crime because you are guilty of committing this crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to states one.
States one is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we had rest and close.
Anything further from the defense?
Rest and close, Judge.
All right, Mr. Woodwine, can you give me the evidence to support the plea?
Yes, Judge, on December 13th of 2022, a vehicle runs from the police. There are 2 co-defendants that are not this defendant. One of those is the driver of the vehicle. When the vehicle eventually comes to a stop, this defendant remains in the car while the other 2 flee the scene. When this defendant is taken into custody, where he is sitting in the vehicle, there are multiple bags of marijuana. The lab weighs to 5.02 ounces of marijuana.
Thank you, sir. Any objections, Mr. Manning?
No objections.
All right, then based on that evidence, court finds that there is enough evidence to convict Mr. Quintanilla of this offense. The court follows the plea agreement reached between the state and the defense. Court convicts Mr. Quintanilla of this offense, assesses his punishment at 9 months confinement in the State Jail Division of TDC, orders a $500 fine, $290 court costs, $85 in reimbursement fees, and the court awards Mr. Quintanilla 102 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Quintanilla, you're hereby remained into the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy. Read on anyone else?
Yes, Judge, I'm gonna make an announcement for Mr. Schmidt on Mr. Pesnell.
Mr. Pesnell, if you'll step up. All right, this is for the record, CR 21-183, motion to revoke on David John Pesnell. Go ahead, Mr. Rainey.
Judge, by way of announcement for Mr. Schmidt, he has not had a offer made by the state or had an opportunity to talk to him about this case. He requested to be set on the evidentiary docket for June 29th.
All right, court sets Mr. Pesnell for contested hearing June 29th at 1:30. That'll be in the courthouse.
Next, Judge, Mr. David Simpson.
David Keith Simpson, CR 23-75, pretrial. Go ahead.
Judge, we were originally going to be proceeding today under a plea. However, when I got here today, Mr. Simpson had some additional information that he wants to discuss with me. And it was going to take a little bit longer. So I would request that you get reset to the June 29th date. And I'll come visit him tomorrow and discuss the new information he has for me.
Is that new information something that's going to be the issue of a pretrial motion? Or is it just something negotiating this case?
I believe it's just negotiation for his case. However, I've not ascertained the nature of what he has, as it was, like I said, pretty lengthy.
Okay. All right, so I'm gonna go ahead and set it for docket call for the 29th. And if you need a pretrial hearing, motion to suppress, something of that nature, just notify the state, notify them.
Yes, Judge.
All right, court sets Mr. Simpson in for docket call on June 29th. 1:30. Ready on anyone else?
Yes, Judge. Randy Young.
Mr. Young, CR 22-349 for docket call. Go ahead, sir.
This case is one involving a co-defendant who is at this time in federal custody. It's a case that I've been in touch with both Ms. Heisel and Mr. Woodwike, but I would like an opportunity to continue negotiations with Ms. Curry. I received some more information about the status of Mr. Murray's case, but I've been unable to confirm it through my sources.
All right, any objection from the state for resetting docket call?
No objection, Your Honor.
All right, court will reset Mr. Young for an additional docket call. June 29th.
And Judge, the next three I did not have listed on my docket that was sent out. I believe two of those were on, from what I understand, a status for jury selection.
Who are those? Michael Law,
And Bobby Shaw.
Bobby Shaw. I show Bobby Shaw's an arraignment.
Oh, I'm sorry, Judge, Jonathan King.
Jonathan. Got a docket call and I've got docket call on Mr. King. Both his cases. Do you need time to talk with them?
Well, Judge, I spoke to both Mr. Lobb and Mr. King. We were ready to announce on Mr. Lobb. Based on some of my conversation with Mr. King, I was unaware as to what our status was for our setting today. If we could have an additional docket call for me to continue negotiations on this case, I received some information from him today that I'd like to speak to Ms. Curry about.
All right, Mr. King, come on up. This is cause number CR 22-331, CR 22-332. Any objection from the state to reset Mr. King for a final docket call June 29th?
No, Your Honor.
All right, court sets Mr. King for final docket call on June 29th. And Mr. Law, CR 22-69. And what did you believe the status was for, Mr. King?
Judge, last I checked, Mr. Lobb was on the rolling trial docket and had been so for quite some time.
That was the purpose of the status?
I'm not sure why that, my understanding was that he was on bond and then got picked up. And that's why he's in our jail.
Yeah, I show that he was on jury selection beginning October of 22. And then he failed to appear in October. He failed to appear again in December. So I guess we'll just, now that he's in custody, we'll just put him back on the jury selection docket. I doubt that he's been removed. Let me look, double check that. All right, we'll put him back on the jury selection docket beginning next week, June 5th. We'll send him notice of each time it's recent.
Yes, Judge.
And did you say you needed time on Bobby Shaw? Or
No, Judge, I just, on Mr. Shaw, my order,
Mr. Shaw, come on up. Go ahead, Mr.
I'm unsure as to what case he sit on today. The way he was explaining to me, he's been indicted on a case that I was not appointed to, so I don't have access to discovery, indictment, anything like that. Nor was I aware that he was set today.
Looks like Mr. Shaw was indicted.
Judge, he was indicted 5/19, so 2 weeks ago.
Judge, would you mind scrolling up just a little bit? Your Honor, Mr. Shaw's name is spelled correctly. Can I understand the charge against him? At this time, he pleads not guilty and requests to be set on pre-trial on this case. As I said, Judge, I don't show on my order of appointment that he's been, I guess, appointed counsel in this case. So we'd also ask that the order appointing me in his other cases be amended to include this case as well.
This is partially evading arrest. This is scanned into the case, it just doesn't say the.
Judge, we also do have, we've not yet received, but we are aware that Mr. Shaw has been arrested for arson on a different date than the impeding case.
I'll get you a new appointment with that on here.
Yes, Judge.
All right, so let's set Mr. Shaw then for pre-trial hearing. Let's set, August 10th. Any objections on that, Mr. Raymond?
No, Judge.
All right, we'll set pre-trial August 10th.
The Judge, I believe that concludes my business. If you'd like, I can wait around until after Mr. Booker's hearing.
Yes, sir, if you don't mind, Also, not concerning you, Mr. Mannix, but is Mr. Is Jay Penny in the courtroom?
Yes, Your Honor.
Mr. Penny. This is CR 22390. Mr. Penny, there was a mistake made by me on my docket. Last time we were in court, I wrote down on my paper docket that our next hearing was June 1st, when in fact, on the notice of setting, it said June 15th. So the hearing is actually June 15th. That's why Mr. Patton is not here, because on the notice of setting, it's June 15th. So I incorrectly wrote June 1st. So I want you to know why your attorney wasn't here, and that was my mistake. So we're gonna come back on 15th as we originally planned. Okay,
Ron, I'm asking.
sir.
So, did you get the letter I wrote you?
I don't review any of the letters that are written to me when you have an attorney. So you need to. That's something that you want me to consider. You need to ask your attorney.
Okay, well, I'm attempted to communicate with my attorney since I've been incarcerated in this jail, which has been 80 some odd days. And he won't accept my phone calls on my dollar that I pay for. Well, he won't answer emails. He won't answer letters. I've had my family call. I've had my family go by his office. I don't know what more to do. He said last time I was in court on the 27th of April, he told me Your Honor and myself, that he had a plea bargain that he thought I would agree to. But if I remember correctly, he said he was afraid to agree to it without running by me first, for lack of a better term, but which is reasonable considering it's my plea bargain. But it's been since April 27th. He still hasn't even told me what that plea bargain is. Like, I paid this man with my money before I was arrested. Well, when I was on bond, before I was arrested currently, I paid him a fairly good amount of money and he's not communicating with me whatsoever. And I filed a grievance with the state bar against him. I even wrote the DA's office to try to find out if they could tell me what the plea bargain was. But I have no idea what's going on in my case, and my family doesn't, and they've been diligent in trying to get a hold of him. My wife has sent many messages to him, and the only message he sent to my wife back was, "Are you still communicating with Jay?" And when she said yes, then he never responded to her again after that, which I thought was a very odd question to ask. It doesn't seem to pertain to my case whatsoever. But I'd like to get my money back from that man. He said he had illness and whatnot, and that's the reason he didn't go to my court date last time. And he denied my motion to suppress because of the fact he wasn't here, which I have no control over. But I'd like to, for lack of a better term, fire him and get my money back so I can try to use it on an attorney who's well-bodied and able to represent me. I don't think that's unreasonable. Is there any way you can make that happen?
Well, let me give you some understanding. You and Mr. Patton have a private contract. He's not a court-appointed attorney. So the only jurisdiction I have over him is regarding appearances in court. And right now, he's your attorney because you've entered into a private employment agreement with him. So you have the absolute right to fire Mr. Patton or any other attorney that you hire. As far as getting your money back, that's also a private action that you would have to take up. You would have to take that up with Mr. Patton, or you would have to file a lawsuit and do that. The court has no jurisdiction over your agreements with other people when they're not filed as lawsuits. So you and your family would need to figure out how to either have him withdraw as your attorney, refund money, hire a new attorney. You're going to have to do all of those things because he's not court appointed. If he was a court appointed attorney, I could help you with some of these things, but he is not.
Well, I've written him a letter asking him to send me a copy of my contract and asking him if he's still falling ill with pneumonia and shoulder surgery and every other illness in the book, that he could just withdraw from my case and refund me my money for what he hasn't done. I don't mind paying him for the appearances he has made, but I don't think I should have to pay him for the motion that he filed that got denied because he wasn't here. I mean, there's no work product from whether he did it or not. If it didn't get presented to the court, it doesn't affect me at all. So that's where I'm at. I mean,
I understand all those things. I understand your frustration, but unfortunately, you're going to have to take those things up with Mr. Patton. There's no court intervention to do that. Mr. Patton is not here today because of a mistake I made. I wrote down June 1. So I expect Mr. Patton to be here on June 15th. Now, if once he gets here on June 15th, then you can raise all these issues with him in person. If he doesn't show up, then that's when the court would be more interested in talking with Mr. Patton about, non-appearance. But until that time, he's the only reason you and I are here today is because I made a mistake, not because he made a mistake.
I'll try to inform the jail staff, but they don't really take me at my words. But would there be an opportunity for me to speak with my lawyer before the Zoom conference at all on the 15th? Because last time on court, I did not get to speak to my lawyer or you at all. And every time I attempted to, I was told to be quiet.
Yes, you'll have access to your attorney before the hearing. And so long as Mr. Patton appears in person, if he appears in person there at the jail, then yes. If he appears via Zoom, I can arrange that. It'd be at the very end of the docket because I can't conduct, private. You can't appear on Zoom, him appear on Zoom, and that's not being involved. We'd have to set up a private laptop in another room and all those things. That makes it much more difficult. So I can have my coordinator email Mr. Patton and tell him that we need him to appear in person so that you can talk with him at the jail.
Thank you very much, Your Honor.
You're welcome. So I'll see you here in 2 weeks, and hopefully between now and then, you and Mr. Patton can get some of these things resolved, and I'll let my coordinator know to let him know that you're requesting to see him before the 15th.
Thank you.
Okay.
Yes, sir. Yes, sir. You can come back with you? Oh, okay, thank you.
All right, I believe that we're ready for.
Yes, sir. Sergeant Davis said he'll be 2 minutes and he'll have him in here.
All right, thank you.
Are you leaving?
No, I'm gonna wait. Okay, everybody.
Mr. Booker, come on over and have a seat over here, please. Just have a seat right there for now. Here. Yes, sir. The judge should return shortly. When he does, and we'll get to the podium.
Is the district attorney here?
I'm sorry.
Is the district attorney here?
No, sir. They're with us via Zoom.
I need to speak tonight, president of the court. I need you to be on the court.
The district attorney. Okay, well, I'll let you bring that up to the judge.
It's no adversarial. Decision tonight. I'm not going to be recommended by him for that outfit. Well, it is with that being critical. Oh, wow. That's what I can. You can move and speak slow. Feel like to allow the. I. Then we got to think about, you know. But, yeah. Yeah. So that you want. See that. Yeah, boy.
All right, Mr. Booker, step on up, sir. This is cause number CR 22-239, State versus Jimmy Saul Booker, motion to revoke. All right, Mr. Booker, we're back again. And I hope that this hearing today goes better than our last hearing. You agree?
Yes, it's you.
All right. Mr. Booker, are you still asserting your right to self-representation?
Yes, Your Honor.
All right. And you understand that you and I had a discussion before you were placed on community supervision, and I inquired into your education, your experience, your background, your age, your legal experience. And at that time, I found that you were able and willing to represent yourself, and that's what you wanted to do. I see no need in going back through those things other than to educate you on the difference between a motion to revoke and a trial on guilt. And so what I'm going to do at this time is I'm going to show you the state's motion to revoke. I'm sure you've probably already seen it, but if not, I want to make sure that you see it before you assert any further rights. Do you have a copy there with you? If not, I want you to.
I have a copy in my cell.
Okay, good. Do you have it with you at the podium?
No, sir.
Okay, well, if you look on the TV right here, here is your motion. Okay, it says that you appeared before the court on February 23rd. You were convicted of failed to register as a sex offender, and that's a second-degree felony. Range of punishment was 2 to 20. That day, the court followed a plea agreement in your case, found that you were there was sufficient evidence to convict you. The court did convict you, followed the plea agreement, assessed your punishment at 10 years confinement in the Texas Department of Criminal Justice, and the court suspended that sentence and placed you on community supervision for 5 years. And during that period of community supervision, you can see here the state filed this motion in this month. And in that, they have filed, it appears to be 4 separate counts, count 1, count 2, count 3, and count 4. Now, these are allegations that they're making. These allegations, the state has to prove in a contested hearing wherein you have the right to confront their witnesses, you have the right to confront their evidence in the court under the rules of evidence, under the rules of criminal procedure. And if they are able to carry their burden, which is a lower burden of proof beyond a preponderance of the evidence, then the state could prevail on their motion. You understand the difference in proof beyond a reasonable doubt and proof beyond preponderance of the evidence. You understand that?
Yes, I do.
All right. And understanding that and understanding what's being alleged against you, understanding the range of punishment, and that the court has already assessed sentence but suspended it, you are still asserting your right to self-representation. Is that correct?
Yes, Your Honor.
And you understand also, Mr. Booker, that I can find you to be indigent today, and I can appoint an attorney to represent you and to assist you with formulating a defense to this motion. You understand that as well?
Yes.
And you're asking the court and advising the court that you do not want the court to appoint you an attorney. Is that correct?
No, I'm going to continue to represent myself.
Okay. And Mr. Booker, let me ask you this also. Are you opposed to this court appointing an attorney to assist you as standby counsel? Meaning
Yes.
that you are still representing yourself, but an attorney would be appointed in one in which you could ask questions regarding rules of evidence, rules of procedure, and to assist you in navigating the legal system. Are you opposed to that?
Yes, I'm opposed to it because I don't think it's necessary. I can represent myself.
Okay. And so you're opposed to the court even appointing an attorney just to stand by to answer any questions that you have, not to argue for you, not to have any strategy, but just to be a resource for you. You're opposed to that.
Yes, I'm opposed.
Okay, and again, tell me why you're opposed to having an attorney that's just available to you, whether you use the attorney or not, it's gonna be your prerogative. But why are you opposed to having an attorney just sitting next to you so you can ask questions?
For the very reason that I desire to represent myself. If I accept an attorney to stand by, it's the same as or equivalent to having an attorney to participate in the proceeding with me. And I find that to be a problem based upon my experience with the court upon attorney, as we discussed before.
And you,
And,
go ahead.
right, and I've lost confidence in the representation. And as you're aware that I represented myself when these proceedings first started. And I successfully had this case dismissed. At the end of that hearing, this court allowed the district attorney's office to introduce a second indictment without it even being presented to the grand jury. And that's why we are here today. Because that was the foundation of why I got the probation when it should have been dismissed in its entirety. And I ended up taking the probation. I took the probation, but it shouldn't have ever got there. The grand jury has not even been presented in the indictment. It's like a last second introduction, and I never had the opportunity to read it, but it just slid right by. That is where, after I met with the district attorney's office, I asked for 5 years probation. That was the agreement. Somehow it ended up being 10 years probation to 5 year supervision. I got documents showing where the 5 year probation was what I was supposed to have. Somebody doubled that from 5 to 10. I had previous representation by Richard Smith. The whole time I was in this Benbow County jail, he was representing me for failure to register my vehicle. This was the whole foundation that this was for. I had registered my vehicle. You found that to be the truth. You dismissed that case. What I don't understand is this. Why are we even here today dealing with the probation? The first appointment I had with probation department, I was practically set up.
Well, hang on, let's do this, Mr. Booker. Today is not a hearing on your motion to revoke, so I don't want to get into allegations. The state's not here today to prove its case, and you're not here to defend your case. Today, we're here strictly to determine whether or not I'm going to allow you to represent yourself. Okay, so let's don't get into, you've been set up with these things. Now I do want to share with you, you've made some allegations already about, things have been changed and things of that nature. I want you to look at this document here. This is the cause number that we're in court on today, CR 22239. And right here, it says 10 years imprisonment, suspended for 5 years community supervision. And tell me this is not your signature right down here. Is that not your signature, Mr. Booker?
Yeah, but somebody must have added that 10 years in there. We in open court.
So somebody wrote in this 10 years. Is there any chance that you could have misunderstood? It does say 5 years community supervision. That doesn't say 5 years imprisonment. That says 5 years community supervision. But it says it's a 10-year sentence and you're on probation for 5 years.
It's paperwork, but I also had an attempt by the probation officer to get me to sign another judgment in Senate. And I refused to sign that.
Well, Mr. Booker,
paperwork on this.
defendants don't sign judgments. Judges do.
Usually, that's why I told Mr. Yan Why are you sitting here trying to get me to sign a judgment sheet for the judge and district attorney? When they should call me to court to sign the judgment. Y'all funneled it to him to get me to where y'all had made that mistake. Y'all sent him another sentencing judgment for me to sign. I signed it, but I noted at the bottom of it that I advised by the probation advisor. And I saw a bunch of dirty paperwork going on. It was like to change the whole plea thing.
All right, so this is what I'm gonna do, Mr. Booker. All right, I've considered, previous to this motion to revoke, I have considered your age, I've considered your background, I've considered your education, I've considered your experience, including your legal experience. And I have allowed you to represent yourself prior to you being placed on community supervision. Albeit today, you're saying that you were tricked into doing that. The court is going to find that you understand that you have the right to have an attorney appointed to you. However, that you are intentionally, knowingly, intelligently waiving your right to counsel. The court's also going to find that you understand that you have the right to have an attorney appointed to you as a standby counsel as a resource. Court's finding that you are waiving that right. But it's not actually a right, but you're waiving the opportunity to have standby counsel. So the court is going to allow you to represent yourself, Mr. Booker. However, the court is going to appoint a standby counsel for you. And whether you speak with that attorney or you don't speak with that attorney is going to be up to you. But this record is going to be very clear. An attorney is being appointed for you so that you can consult that attorney regarding criminal procedure, rules of evidence, strategy. However, you maintain the right to represent yourself. If you never speak to that attorney, that's your prerogative. It's your right to do it, your right not to do it. And I don't care if you talk to the attorney or you don't. But as a court, I'm concerned that I'm concerned about some of the things I'm hearing from you, but I respect your right to represent yourself. I'm going to allow you to do that. And I'm going to appoint the Honorable Jonathan Manning to be standby counsel for you throughout the pendency of this case on the motion to revoke. Okay?
Is this the attorney present here?
I don't know. I can't see who else is in that group. Mr. Manning, are you there?
Yes, sir.
Okay, yes, that's Mr. Jonathan Manning. So Mr. Manning's being appointed as standby counsel. He's a resource for you. Mr. Booker, court is going to set your contested hearing on June 29th. So that's 4 weeks. You're going to have the right then to confront the state's evidence and their witnesses. You'll have the right to present your witnesses, your evidence, and Mr. Manning is available to you as your standby counsel if you wish to use him. If you don't, then that's a waiver, an acceptance of risk that you take on yourself. Yes, sir, go ahead.
That's understood, John. I would also like to discover on this because I intend to prove that the evidence that the state intended to rely on was illegally seized and obtained. And there's also been some false documentation of laboratory tests that were done. I haven't been able to find out what laboratory was supposed to run the test. I went to Mr. Gann's office and took a urinalysis test. We sat there and watched the cup. I know how to read myself because I've been going through the road. And the test was negative. It was not until Wills Point police officer arrested me and found me in possession of less than a gram of meth. All of a sudden, Mr. Gann comes forward with a positive test 47 days later. When he had a whole 47 days to get me arrested if it was positive. That evidence is nothing more than paperwork. Compound officers getting the officers possession. So, but the officer used a confidential informant.
And Mr. Booker, We can't, I've just told you this. We can't get into all of this. Today is not a hearing on your motion to revoke. I understand. So what you should properly do is say, Judge, I would like discovery in this case. And I would say granted. And I would say, state, please provide to Mr. Booker evidence involved in this motion, involved in these 4 counts. And the state's going to comply with that because there's already a standing order that requires them to do so. So they're going to get all that together. They're going to provide it to you at the jail. That's the limitation of the purpose of this hearing. Is there another legal request that doesn't involve you telling me all about what's happening?
I'll get out of I apologize.
That's fine. Go ahead.
I saw parole yesterday. And basically what they're gonna go ahead and recommend that I continue supervision. I was wanting to know, and that way I can meet with the district attorney on this. If I could be granted personal recognizance bond on this.
You've got to file a motion for that. And you got to serve it on the state. You got to set it for a hearing. That's part of criminal procedure.
That's the one I was intending to present to the district attorney today, but I'll get it.
And so now that the court has granted you self-representation, the DA can now talk to you about your case. They can extend offers, they can listen to what you have to say, and they can consult with you on the case, and or they can not if they choose not to. They don't have to make you an offer, Mr. Booker. They don't have to, the only thing they have to do is comply with the standing discovery orders from this court to provide you information regarding the motion to revoke. But if you want to contact them, if you want to send them letters, you're welcome to do so.
Okay.
All right, so we're going to see you back. I'll tell you what, let's do this. Today is June 1st. We're going to reset this case for June 15th. Our hearing is still going to be on June 29th. That's our contested hearing. Let's meet up again in 2 weeks. That way, if there's any other issues that you have, like there's certain evidence that you want that you don't have, that you think the state has, that they haven't provided to you, I'll make sure that you get that 2 weeks before the hearing. All right. So we're going to come back on June 15th. Mr. Woodwag, if you could make some notes in the case and ensure that information is passed forward, that we need to provide Mr. Booker with the evidence that the state intends to marshal in its motion to revoke with regards to counts 1 through 4. And if we do that timely, and then our next hearing is June 15th, and Mr. Booker needs that as soon as he can so he can prepare his defense.
Yes, Judge, I will absolutely do so.
All right, thank you, Mr. White. So, Mr. Booker, I need you to sign that paperwork, and Deputy McLeish, do you have this paperwork here? Is that the paperwork you have?
I don't have any paperwork here on it. In just a second, I'll get the CR number from you.
Well, this is those warnings, and so I'm going to need him to sign these warnings. I can send them over. So, Mr. Booker, I'm going to send this document over, and it's just going to go over your waiver of right to attorney, all the things we've discussed today. They're going to sign there where it says defendant. I'm going to sign down there where it says judge, and that's going to go into the record saying that we've had this hearing. We talked about the inherent risks and dangers and disadvantages, and we've talked about your rights. So you sign that, get it back, and I'll sign it as well. Okay.
Right.
All right. So I'll have that sent over, and we'll have jail staff bring that to you.
And Your Honor, do you have that CR number available?
Yes, CR 22-00239.
Thank you.
And hold on, Mr. Booker, hang on just a second. Ms. Burns, are you still there?
Yes, sir.
Okay, can I have Ms. Taberham email these warnings to you? Can we go ahead and print those out before Mr. Booker goes back? Give him a chance to review those and sign those today.
Yes, sir.
And I think he signed them. He may have signed them on Tuesday, but I'm not sure that I got them back. Hang on just a second. Just stand by for just a second.
Notice
All right, Ms. Burns, Ms. Taberham is going to email out the Faretta warnings document for Mr. Booker to read and sign, and then I'll need those returned so I can sign this.
Yes, sir.
All right, so Mr. Booker, you can just have a seat, and she's going to bring you some paperwork in just a moment. All right, Mr. Woodwhack, I think that takes care of the jail docket. So you're welcome to stick around. I don't want to hold you up if you got other things you need to do.
Thank you, Your Honor. I was muted. I'm usually pretty good about that, but one last time.
One last time. All right, sir. Appreciate you.
Thank you, Judge.
You know. I'm gonna need to file a notice. It's the city, it's gonna stand out there. But you make bail out of it. The only thing
I haven't done anything for the staff. I'm just here, if you have questions from the law, you ask for it to me and I'll provide it, it's like when you. Yeah, that was. Is there anything else associated with it? Well, they just want to know what they have. Jimmy, where'd you get the duct tape at for your pen? Just had to add, man. Oh, those pens are hard to write with. The ones you get on commissary are a lot better than the ones we got. They got some pens like that on commissary, they're a little bit thicker too. No problem. I got mine on. Yeah. I got my bed, but I need to try to get transferred to my thing. We can't do that. Do you have a family member that? It's been 2 months ago. Okay, I called money on my account and I need, I need to, phone call. I can't get a free call, get somebody. Not right now, you can't. But if somebody comes up here and wants your sealed bag that has your debit card on that, and you want them to do that, that's your decision, not ours. Debit card is in my property. That's what I just said. It's in your property, in your sealed bag, and you release it to them, that's your decision, not ours. Get away from it. Ain't problem. Right now, a free phone drop. No, not right now. This guy back there 2.5 years ain't got a free phone call. And still shooting something. Even if I want to bail my check, like today, it went to my hand. I said, go take the bed, mom, give me my card and I'll take it. Take it out of my account. I don't know how to get angry. You can't do nothing if you don't have food stamps. I don't know what bell bonds they do, so. Well, do it. Take it to the bed, mom. You gonna come in? Yeah. I can do that out of my day, so. Well, I'm not giving you a free phone call all day, I can tell you that. My family, most days, they may. But you can, the workers that live off of, was it 7th Street, 5th Street over in Wilson? Right, or you don't want to go 47? Oh, yeah. Well, in town, in Wilson, that's 4th Street, right? Yeah.
But it's, really cut back around to the right, goes out towards. Yeah. Yeah, Rambo, yeah. Whenever you make a meatloaf, I always ate it, it was always pretty good. I haven't tried them. No, I'm not kidding. Last two times they cooked chicken. But that she wasn't here when they cooked. Oh, they did it on their own. They did it on their own. They got a couple guys who are there trying to learn how to cook. They got probably. Almost every last one. Hardly any of them left over now. The delivers.
I have to take that back with the leave. I think the judge wanted you to read over it. Sign it.
Got those in these works. One of my cousins been in out here half a dozen times, but she can't kick the shrubs now. I had a cousin on one terrible point of view. Oh, yeah. They live on 34, 11. You know, just behind the airport. I think it's 3414 you cut off of. And you curve back around from there. And then behind there, it's 30, turns in 30.
Do what?
That road looks like an airplane using guard rails. And no one would describe how many.
I think that's it.
All right, Jimmy, come on, man, let's go.
Hold on one second. You said you wanted to speak to the DA's office, is that correct? Yeah. Okay. Do you want me to see if I can ready to log in?
Mr. Manning. I don't need to see Mr. Booker. I just want him to sign the photo warnings and turn them back in and he's good to go.
Yes, Judge. I was gonna see if Mr. Booker had requested to speak to the DA's office. I was gonna see if we could get a representative from the DA's office to be able to speak with him while he's here.
Oh, I tell you what, I think Mr. Woodwhite just left, but let me call over there and let them know that I can set up maybe a private thing we can get off YouTube and I can put them in a breakout room.
Yes, Judge.
All right, thanks.
Yeah, no problem. They own their own. GMS for years. Is that in relation to the? Well, I don't know, it might be, it might be some third party. The GMS sales over in Terrell, you're on 80 heading towards 40. As long as you are the last thing you see before you leave, as long as you're out there on the plane. That's actually my dad. He started that years ago. He actually started, actually the pawn shop. Most people have used this.
Just pause that.
It used to be an incorporated community.
Hey, Jonathan, can you hear me?
Yes, I can. I believe a judge was gonna try to see if you get a breakout room for you and Mr. Booker to speak.
Okay.
Looks like he's asked us
Join